Partly allowed. Not this piece. RSA dismissed.
Okay.
Yeah.
Before lawsuit for item number 9, today's daily leave, it may be taken at 2 p.m. my lord.
Okay.
2 p.m.
Made PG Lord. Lord, back to me item number 45, Lord. I have for the respondent, Lord. Can it be on Friday, Lordship? Coming Friday.
Item number
45, Lord.
May I
Public.
please? Workshop item number 44, man. Kindly adjourn this matter for today, man.
for the pair made by Mr.
Yes, Ambe. My name is AM. Yes, AM.
Learned for the listener respondent.
Respondent.
The matter stands over for the day. To obtain consent from the other side,
No, my lord. I will inform him.
you first obtain. Otherwise, we will call the matter.
Yes, please, Lordship.
Yes.
Lordship, I mentioned in the item 13 and 14, the conducting counsel is unable to appear to the, due to the illness of his wife. So kindly run this short adjournment.
Your name?
13 and 14. Good name M. Khatunir. M. Khatunir.
M.
Your Lordship, I am for the respondent, Your Lordship. Your Lordship, execution matter is pending before the Honorable RERA. And they are taking their time by saying the appeal matter is pending in the Honorable Guwahati High Court. So always they are taking the time by saying this.
Oh, you from the authority that no appeal is yet made.
Yes.
Order of stay here.
So kindly fix the short date, Your Lordship, maybe 6, 7, 8.
There.
No, any 11, 12, 13 or 19.
Not been protected by Mr.
B.U. Lashkar. B.U. Lashkar.
The matter is then adjourned to be listed on
8.
No, 11, 12, 13 or 19.
11.
11.
Yes.
Nothing. I beg to mention item number 46 of Delhi List, Lordship. I have filed an affidavit regarding Lordship Dasti service that may be checked with the recorder.
46.
46 of Delhi List.
May I please, Lordship? Lordship, item number 27, Lordship. Lordship, the conducting counsel is out of session, Lordship. Kindly adjourn this matter and fix it after 7 August.
Right?
7 August.
7 August.
After 7 August.
Sir, you say it.
D. Kolita.
The applicant you obtain consent from the other side. Not informed. First obtain consent.
May I please? I beg to mention item number 29, my lord. In this case, my lord, I have an affidavit in the overwritten.
29.
Yes, my lord. That may be allowed to take with the record, my lord. And another matter, my lord. Part of matter. It is related to pensionary benefit, family pension. That was fixed on 23/5, my lord, but not listed. That may kindly be allowed to be.
Number 8.
My lord, it is part of matter.
Order.
Yes, my
When do you want?
lord. But day after tomorrow, as your lordship's convenience. Hearing is yes. 21st.
Wait, Mr. Lordship. Lordship, I beg to mention item number 88, Lordship. I'm for the respondent, Lordship.
I'm for the petitioner, Lord.
This matter may be passed off for today, Lordship. This matter may be fixed on
Yes,
20.
agreed by learned advocate of the but the matter is then over for the
Can it be on 28th of August, Lord? 20. Much obliged, Lord.
Obliged.
Lordship, we have informed. Item number 27.
27. Okay. On the pair after
7 August, any date, Lordship?
it is part third method.
No, Lordship.
Wait, please, Your Lordship. Lordship, I have another prayer. Lordship, with regard to item number 43, this is a transfer petition, Lordship. I'm for the respondent. There's some development has taken place, Lordship. The matter is in the mediation, Lordship. The other matter, Lordship. So this matter may pass off for the
Item
day.
number 40.
43, Lordship.
Now, what is your prayer?
Lordship, this matter may adjourn for 2 weeks, Lord.
For
Petitioner.
for 2 weeks.
Obliged.
Yes, please, sir. This is a third time bail application prepared before your lordship. Earlier, 2 occasions your lordship was rejected and also directed to the trial court to expedite the trial of this case. But till date, out of 16
And
witnesses,
what it says it is pending.
lordship,
And what it says it is pending before the trial court.
for evidence, lordship, only one witness examined out of 16 witnesses till date. More than 3 years, petitioner behind the bar, lordship.
With the theater record or that
ABT,
learn it for the for the and also hard me
R. Hussain, Your Lordship.
or then learn it on the behalf of the
SC Your Lordship.
learn
NCB.
the gain or by on the bulb. Then with the the 20 and second. Raising out of NP HCP Guwahati crime number number 5 the learned only for the give success. This is the second bail application.
third time, third way.
Third bail application. And the first and second bail application were elected by court by order dated
9/1/2023
9/1/2023
and
in P number 595 and
6/6/2024.
and on 6/6/2024 P number 383 and further the learned not for the sunset. The case is the state of evidence and declare one that another suspect is considered of that better. You of the subject of the learned like you result of the record of the learned trial court is found to be accordingly provided that can copy of the record of the learned trial court. The trial court fixing the matter on
Obliged.
Lordship, matter may pass off for the time in the English Council.
another court.
Can be referred to mediation, Your Lordship, because they have filed it only for enhancement. So can be tried for mediation also.
Can
Yeah,
it
that-
be
that will
heard?
Yes, yes.
Let the conducting counsel come.
Come six. Here, Lordship, actually, the other side has also, insurance company has also preferred an appeal, Lordship. There was a delay, in the delay notice was issued. I have received notice in the delay, Lordship. In the delay, I have the number of the IA, Lordship. The MSC appeal has not yet been numbered. If it is listed for mediation, then both may be listed together.
So, is there any chance for settlement with the
Lordship, otherwise, I don't think so, because they have also preferred an appeal. They have also preferred an appeal, but
then why should we refer the matter to the
then Lordship may fix a date for hearing, Lordship.
hearing?
Along with the other matter, Lordship. Other matter,
That is yet to be admitted.
Yes, Lordship.
Yet-
Delay has not been condoned yet.
delay has not been controlled.
Third matter,
GJ Sharma, Lordship.
third is for the appellant. Then we have the respondent.
Respondent number 3, Lordship.
Respondent number
3.
So the matter is set under the column for referral to the special magistrate right medical for the it's submitted at the bar that there is no likelihood of settling the dispute magistrate, and it is also submitted that the respondent number 1 Sola MS General Student Competitive and others also required one appeal and something yet to be admitted as one delay IA number
1, 2, 3 of 25.
1 5 and that both the matters that together on next step. Accordingly, provided that the IA along with the appeal number it will go on
Obliged, sir.
Quickly oblige.
for the all later.
It is your Lordship. Lordship, this matter I'm appealing on behalf of Mr. A.K. Gupta. He has some personal difficulty today. This matter may pass off for the day, Lord.
For the day.
Yes, Lord. Lordship, can it be fixed on 13/8, Lord?
But did you
Yes, yes, Lordship. I was supposed to mention in the morning, but Lordship, I however skip, Lord.
Emperor
13/8, Lordship.
38 there
Obliged.
after
Yep, no. And for time being, Mali. As per the direction also have already selected.
May please.
Yes.
Second appeal, my lord. and already connected second appeal. Second appeal we have filed, my lord. That is already admitted, my lord.
When?
My lord, it is
It is
admitted.
the same judgment.
It's a judgment because initially, my lord, we are the plaintiff, my lord. The suit was decreed in our favor. The counterclaim of the defendant was rejected. Against that, they have preferred only single appeal. In that appeal, first appeal, my lord, our suit is dismissed and his counterclaim is decreed, my lord. Against that, initially we have filed one second appeal, but there is 2 degree. Therefore, we have to file another appeal with condonation. The condonation, delay condonation petition is allowed, my lord, and delay was condoned. Now for my lord admission. So, my lord, utmost question we have filed this second appeal, my lord. And the same substantive question of law will be involved in this second appeal, my lord. We have annexed the, my lord, that earlier order, my lord, at page 20, my lord. Earlier second appeal. It is pending now. The 1 and 2 is there, my lord. Substantial question, and we pay for allow us to formulate any other substantial question at the time of hearing.
So, same substantial.
Yes,
question
my
also
lord.
be framed here.
Yes, yes.
Or or it's appeal under medic it's not or 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 and 49 of here that I and it was the court the earth the by court of birthday Kamrup and that is 49 of 12 and thereby they decide the judgment and dictate caused by the number 3 case number trial court and decree the counterclaim and part 1
Vision. Take a learned appellant said against the same judgment and decree. The who preferred the appeal This appeal.
and then the other appeal,
Appeal also we have filed.
the same appellant has
Plaintiff
also
plaintiff
preferred
appeal.
another appeal, being RSA number 117 of 2017. And the same is
117/2019, my lord.
2009.
Yes,
And the same that is by court by order dated 12/6/2019, framing substantive law and that the same law are involved in the presentation of and the same recording and the part of yes, Madam Lapa,
I am for the respondent, Lordship.
so according to Mr. Decker, the substantial question of law are here of any objection?
No, Lordship.
No. But I have heard the substantial part of the party by the memo of appeal and the count here and also the substantive law. Then the chief judge dictated to pass the trial and also the order of put in a time of court in article for one that dated 12/6/2000 is affiliated to the former substances the learning of the by part the mind trial for in whereas number 4 related to like appellant cycle over the length is concerned. For whether that the concurrently consider learning appellate or something of as there is a bit part separate against the defeat paper of the plain appellant and sense of interference by the learned appellate court. The court may also consider when of further substantive law is found necessary at the time of hearing after duty of strength suffered. It's noticed the response returned for how much for
AB cast.
AB
Cast.
by the entered evidence of all the respondents
Yes, Lordship.
and
Yes.
Yes, Lord.
how by copy of the memo of evidence for this is called for the record learned court then read the method along with and take the method along with partition number 1
In this case, Miller already status quo is there earlier or second appeal. Status quo may be granted, Miller.
No, we have directed to take both the method together.
Yes.
Yes,
Yes.
Lord.
I number 647
Yes. Yes, Miller.
for grant of stay.
Yes, Miller. Yes. What I get.
But in that IA, the name of Mr. Bhagavati has been selected.
Bhagwati is my, he's working with me, Miller.
Okay.
Same September.
But this IA is not listed today.
And right, it's one. Okay, Miller. Next day,
Next,
already status quo is there, Miller, in that appeal. Miller.
okay. On next day you give me
Yes,
my
yes.
result. Non-appeal for the appellate clause. After one step,
Your Lordship, extremely sorry, I am appearing on behalf in item number 19 on behalf of the respondent.
later on, Mr. Your name
A Banerjee on behalf of N Sarkar.
A Banerjee, learned counsel,
On behalf of
appeared on behalf of Mr.
N
N.
Sarkar.
Sarkar, learned. This is the matter of
Item 21.
नानक थोड़ा appellant not one
22.
Yeah, Chris Lordship. I have departed Bill Lordship, but so the address of the sole respondent was incorrect, Lord. That's why now I found the correct address from the district collector, district commissioner. That's why I may be allowed to take a fresh step to the correct address, the sole respondent, Lord. It was order dated Loazima Court Lordship 22/1/2025.
this I is for what purpose?
I saw delay condemnation, Lordship.
Donation.
Lordship.
What is the idiot?
One title should was preferred by the opposite party, Lordship, respondent by that was
Oh, the period of delay?
the delay of 85 days, Lordship.
Are you sure?
Lordship.
But in the petition you mentioned that the 119 days.
109.
Lordship, in IA, Lordship.
Yes.
It was mentioned here that 85 days.
Did I number 1618 of
1618/2020.
the quick step or the 119 days? Yes, any objection?
We may be given time for filing also. Because Your Honor, it is 85 days is mentioned in the delay condonation and 119 days is mentioned.
Or Mr. Gokul learned government advocate for the applicant.
Lord.
And Mr.
W. Hawk on behalf of Mr. A. Sattar.
Learned complete job of Mr. Yes, sir. Learned opposite party. Learned complete for the opposite party. Something something but it's the method on when
As your Lordship may please.
May I take first step to the whole respondent with correct address?
yes already
Lord. Lord.
why is that
Here is Lordship, address was incorrect, Lord. I
he appeared?
Yes. Obliged.
Please, Your Lord. Lordship, this matter has been abated because the respondent number 2 and respondent number 9 expired on 12/3/24 and 26/8/24.
But petitioner is absent. Go for the response.
Yes. Respondent number
For the both half of the
S. Afridi.
S.
Afridi.
Afridi.
On behalf of D. Gosi.
appeared. Oh, respondent number
113/328 and 10/11.
8, 10,
10/11.
Afridi subset respondent number
2 and 9.
with 9 suffered divide. Then that's the matter. This the matter after the event of subsequent conversation.
August.
My Lord, this is a IA is in file under section under my Lord order 39 rule 3 CPC. My Lord, for granting a temporary injunction in respect of the my Lord property. In view of the my Lord, the level court order passed in the RSA, that is annexure 1 at page Lordship will get it from the 12th page it is started, and the relevant portion at my lord 13, whereby the title execution case number 5 of 24 was my lord state. My lord, in this case, after what happened, my lord, when the stay order was continuing, the my lord, respondent side my lord, initiated certain construction over the disputed land, by which my lord, they totally blocked my ingress and egress. So in respect of that, I have filed one FIR before the Mahabharata police station, that is Annexure 2 at page 15. But no action has been taken by the police concerned. That is why my lord, I approached before Lordship. At least my lord, to direction may be given to the respondent side not to raise any construction over the land and dispute, and not to block my ingress and egress, my lord. So in that respect, already notice has been issued to them. And if it is my lord required, my lordship may call for a report from the police also, from which it will be very clear that whether any such a violation was there or not.
Please, your lord. My humble submission is that my instruction is otherwise, my lord. My instruction is both the court has held in my favor in the court below, my lord. My instruction is that, my lord, they are interfering with the sweet land money in spite of pendency of this appeal. So, my humble submission is that both the parties may be directed to maintain the status quo till pendency of this appeal, my lord. So,
My lord,
you will not
without-
actually agree, my lord. So, both the parties may be directed to maintain status quo, my lord.
Without my lord ascertaining my
So
lord, my
that's what means, my
allegation,
lord, they are in possession of the land.
One by one.
My lord.
without ascertaining my allegation, my lord, how this can be valid? It is already my status quo there. We are maintaining the status quo, violation from their side. So for that, my lord, we have approached the police authority, and let the my lord, is one inquiry may be done by the police in earlier occasion also. This type of things was my lord happened.
So one, second, file a
My lord.
Well, by this time, that can be filed, my lord. But by this time, lordship and so, my lord, call for a report from the police in view of my this affair, because there is a palpably there is a my lord, violation.
Well, if there is violation, my lord, they have preferred, my lord, also have filed an application for violation, my lord.
No, I am filing my lord order 39 rule 3. This is also applicable in this case of when the appeal is pending. If something is going against the order passed by the honorable court, that I can approach before the court, my lord, and court has ample power. Lordship can call for a report of the police. Where is the objection, my learned friend?
And since, my lord, execution has been stayed, my lord, as he submitted, my lord, then what is the harm in, my lord,
That is why.
my lord, maintaining status quo by both the parties, my lord?
That is why.
Appeal has already been admitted, my lord.
My lord, why I before lordship? There is a violation. They have, my lord, raised a construction over the land disputed, which has been stayed by honorable court by in the execution case, and the, my lord, they have totally blocked my ingress and egress. That is why I before lordship. So lordship can call for a report from the police, and my learned friend cannot have any objection on that issue. If something is found, my lord, that according to lordship will pass the order. Let them file by the objection by this time. By the same time, lordship can call for a report of the police.
Well, violation cases is a different, my lord, proceeding altogether, my lord. They have to prove by giving evidence, my lord. That cannot be proved here, my lord, at the appellate court, my lord. They have simply prayed for a status quo order, my lord. I am not objecting to that, my lord. I am simply saying that, my lord, both the parties may be directed to maintain status quo.
The status quo, all right, my lord. My lord, all right, my lord. Then I am considering his, my lord, fair. That as per the, my lord, as on, my lord, date, this is on 39/2024. As per on that, my lord.
No, my lord.
Status quo to be as on, my lord, that day. Then why you are objecting, my lord? Status quo as on date of the passed by the honorable court. That should be status quo to go to that order, my lord. Subsequent status quo cannot be. If subsequent status quo is there, that means he has violated.
No, my lord.
I am not objecting that there is status quo as per the 39.
I file my objection, my lord, because as per my instruction, well, they have interfered with the land records, my lord.
Land record, my lord.
So that is my instruction, my lord.
Land record. Land record is
my instruction, my lord.
Land record, whatever is referred here.
That's why I was not objecting, my lord, to his prayer, my lord. I was simply praying that both the parties may be directed to maintain status quo till the appeal is disposed of.
All right, my lord. Status quo as on, my lord, 39/2024.
No,
that has already been ordered.
No, that is why, my lord, they violated.
Why second
My
order is there?
lord, because, my lord, they have raised a construction on my land, disputed land, blocking my ingress and egress, totally block my entrance. That is why before lordship, my lord. No, I totally, my lord, agree with lordship. But at the same time, lordship may call for what, my lord, things will happen, my lord. Nothing will fail.
We'll see later on. Not they will.
No, my lord, I am suffering, my lord. Lordship can concede my lord, my statement, my lord.
So also you see under which provision I will call for the report.
No, my lord.
My lord.
Not my lord.
Under which provision I will call for the report from.
My lord, this is order 39 rule 3.
Is it provided?
Yes, my lord, lordship has ample power
No.
to decide whether, my lord, this, yes, my lord. Lordship has ample power to call for the report from the police as per this my lord provision.
You show me the provision, and if
No.
there is that.
No, my lord, then my lord, lordship, from where it will be decided by the lordship that there is a violation, my lord.
No, on the basis of materials pledged by you before.
But this is my material I placed before your lordship regarding the filing of the police case. So what they have done on basis of the police case, my lord, that can be called for the report from your lordship, my lord. My lord, it is very, my lord, clear, my lord. Lordship, I have clearly, my lord, stated my lord affair that what happened in this on the land after the passing of this traveler, and the police has not taken any action. So, and that is, my lord, lordship can pass the complying the order, my lord.
Then you file that.
But-
Or- File it.
No, short, my lord, one short date maybe began, my lord, earlier occasion they have received the notice. They have till today, they have not filed the affidavit, my lord. One short date, my lord.
My lord.
Mass of this, my lord.
My lord.
Mass of.
May I please, your lordship? Service is complete, lordship.
Complete.
Yes, lordship.
Third,
P. Sharma.
third,
W. Hawk on behalf of Mr. Asad, sir.
third, third. It's submitted at the bar. Action hearing.
Yes, lord.
Submitted on
Date may be fixed.
after doing for admission hearing.
Date kindly, my lord, fix it. Obliged, lord.
Obliged, lord.
Okay, next time.
Please, your lordship.
There is a IL lordship for condonation of delay of 41 days lordship in preparing the MSc LK lordship. And as per the office note lordship 17/7/25, their service has been completed upon the all respondents. Number 1 has filed their Okaratama. Number 2 and 3 it has been received lordship.
Respect respondent number 3.
Lordship, their worker has received
Worker.
in the sector.
Can be like start.
Lordship, because he's the owner of that factory.
Oh.
The restaurant number 2 and 3, because father and son, both are father and son.
The worker is the
Lordship, worker is employee, Lordship. That is their establishment.
respondent number
2 and 3 are father and son.
Father.
Lordship.
And the worker of the their worker is
Received that.
Can-
That's Lordship, because it will definitely will be come to his knowledge.
is provided in the
In his place, Lordship, in his establishment, Lordship, it has been served.
better one like then thereafter you let it put after some time.
Lordship.
My lord, there is a delay of 226 days, my lord. I have explained in my para 2, 3, and 4, my lord.
Whether knowledge was served.
Yes, it is served, my lord. They are represented.
In respect of respondent number 9.
My lord, in respect of respondent number 9, my lord, it is minor. Respondent number 9 is minor, my lord.
Who represented?
Respondent number 3 is representing, 3 and 4 representing.
Where you have mentioned it?
My lord, it was not mentioned, but 3 and 4 is being the son, all are son. My lord, 5, 6, 7, 8, 9 are the minors, my lord.
And in respect of respondent number 1.
My lord, in respect of respondent number 1, my lord, Bajaj Alliance, my lord. Respondent number 1, Bajaj Alliance already entered appearance.
Who appeared for Bajaj Alliance?
My lord, my lord, my lord, today I am unable to go through the records, my lord.
They are unable. But it is sir.
My lord,
No, Mr. Sir.
respondent number 2 and 10 entered appearance and as per cause list dated 19/2/25, my lord. It was there.
3, 5, 6, and 4. But Mr. S. Ali, Mr. B.
If
Okay. Sir Talukdar,
my lord,
as per system, one of Bhagat filed for respondent number 1,
Yes,
but it is not on the record.
Yes.
One thing, but we consider that the outcome of one was regarding evidence of conflict
yes, my lord.
or by a Talukdar burden applicant. The Talukdar suggests that one Kalatnama has filed on behalf of the number 1, then the respondent number 10 might be represented by respondent number
2, 3.
2 and 3.
Yes, my lord.
And as such are being webbing but the side that regarding filing of Kalatnama by Ladakh of provided that verification of an update of on starting of
Public.
My lord, in this case, my lord, I have filed everything opposition, my lord. And
that's not okay after some time.
my lord, it may be, my lord, after in next week, my lord. My lord, I have another case in court number 3, my lord.
Okay,
Next week, my lord.
or
And
the Talukdar or appellant. The Talukdar suggests is filed one affidavit respect to service
no, my lord, not service or it is against IA, my lord.
of the respondent.
Yes, my lord. Yes, school ration.
Condonation of delay.
No, my lord. It is for maintenance, my lord. Maintenance and ceremony, pendant lighting.
How about the Talukdar
On 1/8/25.
on
1/8/25. 2025, my lord.
May it be pleases you, Lordship. Here, your Lordship, perusal of your Lordship service completed on dated 31/7/2025 on records. Copy was received by the elder brother of the respondent.
Wait,
One date may be given, your Lordship. One date may be given, your Lordship, to appear, your Lordship. Short date may be given, your Lordship.
was served.
Yes, sir.
But no one entered a bit of the system was
Uh, 18 August.
kind of of indicating whether conflict or evidence on behalf
Interim order may asked earlier. Shall continue. I'm deeply obliged.
Lordship, matter may be taken up for some time.
32.
May it please your lordship, my lord. Allah, here in this case, my lord, execution has already been done, my lord.
Matters
That
become
also
infrastructure.
office report my lord, petition become
That
infrastructure.
may be closed, my lord.
Matter can be disclosed.
Okay. Part PK the part started from
Yeah, you.
the one
Yes.
is submitted the part that the degree has started
That is also official report is there
Yes.
also my lord, dear my lord.
And that's correct.
and
Already been executed.
Executed.
the degree has already executed.
Also to the order dated 23/6/2025 my lord, passed by this honorable court in the present revision petition my lord.
Order was the court dated 23rd
23rd of
25
my
and the report that affected the our
we have also got the possession of this suite house my lord, pursuant to the execution of the decree.
here. The order dated 25/7/5 and also the report dated 25/7/5 of the executive officer that position of the legal
The decree holder my lord, decree holder. I think two position my lord, decree holder.
yes. Above this matter become
Yes. So, obliged.
Obliged.
May it please your lordship, this I is filed for condonation of delay of 707 days. And the reason of delay is explained in para 3 of the I.
Lordship, in this case, we have not received the copy of IA. Only the appeal petition has been received.
We'll provide it.
one file object
I am for, yes, Lordship.
part
S.A. Wasi.
S.
S.A. Wasi.
that a was the applicant and the
Lordship, I am for respondent number 2.
part 2.
It also there, Lordship, respondent number 1.
And the Gogoi to respondent number 1.
1, Lord.
You also want to file that object.
I also want. Because of it, 770 days
The learned
delay.
order part of that, not part that recording by the test, but part of that. Learned part learned one by get up
Not obliged.
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 May it please your lordship. Lordship, as per office note dated 31/7/25, respondent number 1, 3, and 7 has filed wakalatnama. Service is not complete in respect of respondent number 4, 5, and 6. Lordship, 4, 5, and 6 can be struck off.
I am appearing to the respondent number 7.
Or F or 7. Yes, then that's of 5 up or 5 are that their name is track of the array of the epic recording taking up the name of that of that 5 can track the array of the constant of the non-empty 1 3 and 6. Whether
Lordship,
notice of them are
6, respondent number 6 notices service is not complete, Lordship. So respondent number 6 may also be struck off, Lordship. 4, 5, and 6.
5. Then 1 and 3
They have filed wakalatnama, but it is
it's the matter on when
any.
the file objection here.
I have not.
Respondent number 3 has filed objection, Lordship.
Please delay me.
28 days. delay.
28 days.
28 days. delay. Respondent number 3 has filed objection, Lordship.
Let us fix a very sorted
Yes, Lordship.
in the number 3 is not represented by
Obliged, Lordship.
May I please, Your Lordship? My lord, the matter is arising out of the financial relationship, and the matter has already been settled in between the parties. We have already vacated the premises by 31st of July, my lord. So that's why this IA has come. For that, there is a compromise application, my lord, along with that. So we want to withdraw this here in view of this compromise.
Why
For the respondents, Your Lordship.
all the
All the respondents.
is application order 23 was or by the application taking it of the court so there is by Kabul one memorandum of understanding of 18 the third applicant method has set up part and five for record part CRP for MC. Why are also that set up with the part and allowing record of understand of the value of taking party better happen about here part then both of all draft in terms of the understanding of the of acting
Obliged.
This IA is for condemnation of delay of 60 days. Lordship. So at this time, notices may be
30
60 days.
38.
138 the
39.
But there is delay of 101 days, my lord. Because of earlier I have filed second appeal and that was withdrawn, my lord. In the process, my lord.
Okay.
101, my lord.
So under 614 how did you get
My lord, there was no delay.
notice?
No delay. That order I have annexed in original civil division, page 64.
Let notice go.
My lord,
Let notice go.
there is actually there is order passed by this honorable court.
That's
my lord.
right. Dependent it is considered here done. You take a step after or
Then date may be fixed because yeah, I'll take steps by today. Because earlier second appeal was not barred by language.
yes, I have remembered it.
Yes.
Item number 38 Lordship, I have just missed 38 Lordship.
Okay. It is for confirmation of delay.
When was the delay?
Okay. Not. After
Here.
for it.
Lordship, my senior is another court, please, fixed at 2 p.m.
My lord, this is regarding service is just complete, my. So it may be fixed for admission hearing today, perhaps can be. Services by the Lojima court is said that service is complete, my. Kindly have a look at the last Lojima court order.
Service both are
Yes, my lord, kindly have a look at the last order of the Lojima court. Dated, my lord, 12/6/25.
S.A. Islam, behalf of
K.
K.A. Muzumdar.
behalf of
K.A. Muzumdar.
K.
K.A. Muzumdar.
Response for 144.
Respondent number 1.
One. After 1 week.
My lord.
After 1.
My lord, the interim was there, may be continued. Interim stay on the lower court.
Order.
Obliged.
Please, Your Lordship, I'm appearing on behalf of the respondent. Your Lordship, it is a transfer petition against a pending divorce suit pending before the learned principal judge family court, Tamil Metro, Your Lordship. Your Lordship, the divorce is pending before the family court, Tamil Metro, and the petitioner is filing this petition for transferring the case into Nagaon district, Your Lordship. Your Lordship, the petitioner, the respondent, once filed a case in Nagaon district, but due to the threatenings, constant threatenings, and some personal problems between the petitioner and the respondent, the petitioner shifted to Guwahati. And therefore, since then, she lives in Guwahati and Guwahati Sonapur. And from Sonapur, she attends her duty. If she works in a school, the school is situated in Nagaon. As she lives in under the jurisdiction of Kamrup Metro District, that's why she filed a petition, divorce petition in family court, Your Lordship. And now the husband has filed this petition, transfer petition, alleging that she stays in Nagaon as their workplace is Nagaon. Already the case is stayed in family court, Your Lordship.
The petitioner is absent. Not how about
S. Jed Hayat. Jed Hayat.
Hayat.
Your Lordship, may we file a reply, affidavit in opposition in between, your lordship.
Yeah.
Affidavit in opposition,
When?
within 1 or 2 days, your lordship.
That, that's about, about, like, response. After 1 week.
Sure. Reply obliged.
Uh, okay, for the-
44.
May I please adjourn this matter for today. I am for the respondent.
if from the other side, no.
I have
None
not,
appears for the both our third.
yes, submit.
A is on it, but it's submitted after 2 weeks.
I have filed a Kalatnama today itself, my lord.
Today?
Today, yes, my lord. And, my lord, I pray for fix it to 13 or 14, my lord. I will file a reply, my lord. Because some urgency is there, my lord. Our case is.
M. Boro, Lordship.
M. Boro, for the petitioner.
Yes, sir.
Then the put for respondent, all the respondent.
My lord, sole respondent.
Sole respondent. Then you file say, and raise for done of the file objection. Where is the
Lordship, there is stay order, still, there is a stay, Lordship. That may be.
order password.
All right.
May please, your lordship. In this case, notice was issued, lordship, service has completed, lordship. So let the matter come up for admission, lordship. Name is shown, lordship, for respond number 1 and 2 appeared.
The third.
Yes, lordship.
My lord, my amendment petition was allowed, and that's why the learned counsel is before your lordship. Impugn order is, my lord, I did.
Let the matter come up for admission, lordship, some other day. Any date, lordship, for admission. That they made, lordship.
What does it say? For 1 and 2.
Yes, my lord.
What does it say? Service is action. That is allowed it. Submitted on.
Interim order may mistake. There is stay order, that may be continued.
Interim order password.
Obliged.
Obliged.
May I please, your lord? Lord, here in this case, we are appearing for the petitioner. My lord, we have taken steps, your lordship. Lord, office note dated 1st of August 2025 says, my lord, that registered post 80 not returned. Usual notice served, report not come. Thus the service also, my lord, not. Therefore, my lord, let us wait for some time. The service report may be awaited, my lord.
No, where is your affidavit?
For Dusty, Dusty, my lord, Dusty is not complete, my lord. It is not returned, my lord. Therefore, we could not file, my lord, any.
Okay. Part the PSN burden. It's the sense of its set. And there may be that after 1 week or 2 weeks.
2 weeks, my lord.
2 weeks. Everything served report upon 1 to 3. That is accordingly allowed. Submitted after 2 weeks.
So interim order passed earlier. May
Interim
kindly
order
be-
passed earlier. Help.
Deeply obliged.
Item number 5.
May I please your lordship. In this case, your lordship, service report in respect of respondent number 1 and 2 has been awaited. Your lordship, awarded amount has have to be paid by the insurance company and owner also. Therefore, their appearance is necessary. Your lordship.
That number 1 and
Yes, lordship. Insurance is appear. Respondent number 3.
number 3.
I'm for 3.
So
as
you
per-
have to take price upon respondent number 1.
Lordship, maybe.
Okay.
Otherwise,
Third,
yes, I can.
third is
Appeal.
second also
পুরো
number 3.
তিনটা ওনার ড্রাইভার নেই
Sir, I can third and
Appeal.
second. Third and dated
16/6.
right. Third is card. By the 6. Order of the price of one of the BTP registered area.
Lordship.
Or
Lordship. Problems.
May I please, Your Lordship? It's a regular bail application, my lord. 30 case trial is going on, my lord. My lord, can you see the page number 12, my lord? This is FIR.
page number
12.
this
An
is
extra.
first or second or third application.
No, my lord, first application.
First application.
My lord, they are trying to the learned trial court before the trial court, my lord, for bail application. But recently the bail application, my lord, was rejected, my lord, for which they have come before this. No, like, my lord, this present petition is the
Page number?
my lord, page number 12.
Yes.
It is actually submitted that the below mentioned accused persons are the causing mental and physical torture upon by the married daughter Rohima Khatun, age about 22 years, on last 2 to 6, 2023 at about 12:30 p.m. noon time. The accused person started a quarrel with my the daughter, and thereafter they have physically assaulted my daughter, and thereafter the caused injury to her lips and face, and thereafter poured the kerosene oil in her the body and set her the ablaze, and thereby the caused grievous injury to her. After hearing the hue and cry, the nearby the villagers came to the place of the occurrence and took her to the Dhubri Civil Hospital for unconscious condition. But due to serious condition, the doctors referred to my daughter to Barpeta Medical College, but thereafter she died. In this regard, my lord, there are the total 6 number accused person, my lord. My lord, after filing this FIR, my lord, accused number 1, my lord, there is a prime accused. He is the husband of the victim, my lord. Then, my lord, the accused number 1, Rugul Hussain, and his sister, my lord, Firoza Baby, they are arrested, my lord. Subsequently, they are released on regular bail, my lord. According to charge sheet, my lord, rather than charge sheet file of the Concha, my lord, my lord, the name of the Johurul Hussain, my lord, number 6, my lord, his name, my lord, discharged in the name of the case, my lord, as because there is no sufficient evidence, my lord. And my lord, Regina Khatun, my lord, accused number 3, my lord, she was the juvenile.
Where did that?
My lord, Inamul Haq, my lord, sorry, Inamul Haq. Inamul Haq was discharged from the case, my lord, due to there is no sufficient evidence. Inamul Haq. And my lord, Regina Khatun, she was juvenile, my lord, at the time of the occurrence, my lord. Also, her name was discharged, my lord. Now, my lord, the present case trial is going on, my lord, against the court.
Also discharged.
Juvenile, my lord.
Yes.
My lord. Now, my lord, the trial is going on, my lord, against the 4 number accused person, my lord. My lord, number 1, Rugul Hussain, and number 2, Firoza Baby. Firoza Baby is the sister of the prime accused, and parents of the accused, prime accused, my lord. Parents, my lord, present petitioner, my lord. They are the father and mother, my lord. My lord, kindly see the page number 31, my lord. Page number 31, my lord. Page number 31, my lord. After receiving the summons before the learned trial court, the parent of the prime accused, they appear before the trial court for start the trial, my lord, face the trial, my lord. Then, my lord, one bail application was filed before the said trial court, my lord. Same was rejected, my lord. In the said order, my lord, prime accused, my lord, Rubul Hussain and Firoza Bibi are present, my lord. Till today, Rubul Hussain and Firoza Bibi are appearing before the trial court regularly, my lord. Except this present petitioner, my lord, they are inside the jail, my lord.
They have been granted bail.
Yes, my lord. Yes, my lord. They are appear outside, from outside, my lord. Yes, clearly mentioned, my lord.
When they have been granted bail.
My lord, recent after 3 months, date of the arrest, my lord, from the arrest, within 3 months, my lord. Yes, because my lord, charge sheet was filed after 9 months, my lord. After 9 months, my lord.
9 months.
9 months, my lord. And my lord, trial started.
Why the present applicant's bail application was rejected?
My lord, that time, my lord, the bail petition was filed before the Chief Judicial Magistrate, my lord. It is a session trial case, my lord. For which, my lord, that bail was rejected and remanded to the judicial custody, my lord. From the 12/11/2024, since that day, my lord, they are behind the bar, my lord. They are the parents of the prime accused, my lord. They are inside the jail till today, my lord. And prime accused with his one sister, my lord, Firoza Bibi, they are in outside, my lord. They are appearing before the trial court regularly, my lord. My lord, my prayer is that, my lord, as because, my lord, they are the parent of the prime accused, my lord. And after marriage of his son, my lord, Rubul Hussain, my lord, they are residing the separate accommodation, my lord. We are repeating the separate accommodation, my lord. My lord, we are the parent of the prime accused, my lord. And my lord, till today, my lord, 8 months, 23 days already behind the bar. 8 months, 23 days, my lord, behind the bar, my lord. We are the parent of the prime accused, my lord. And prime accused, my lord, now he is outside, my lord. He is appearing before the trial court and face the trial, my lord.
Till now, charge has been framed against them.
Yes, yes, my lord. Yes, my lord. That's same, my lord. Yes, my lord. Page number 31, my lord. Page number 31, my lord. Order dated 12/11/2024, my lord. It is clearly mentioned, my lord. Page number 31, my lord. Accused Rubul Hussain and Firoza Bibi are present. Accused Jahirul Haq and Ramiza Bibi, this is two of the present petitioner, my lord. They have appeared and filed petitions so paid for the allowing them to go on bail. My lord, heard the both sides, the peruse the case diary in this IO submitted the charge sheet against the person under section 120P 30234 IPC showing the cause Jahirul Haq and Ramiza Bibi as absconder, my lord. In the charge sheet, my lord, that is the main ground, my lord. Their name has been showing as, my lord, absconder in the charge sheet, my lord. Though, my lord, after receiving the summons from the trial court, my lord, they appear, my lord, before the trial, my lord, and ready to face the trial, my lord. And then, my lord, immediately, my lord, landed trial court, my lord, the bail was rejected and they remanded to the judicial custody, my lord. Same day, my lord. And from that day, my lord, they are in judicial custody, my lord. And prime accused, my lord, they are outside.
Examined till then.
My lord, 4% out of 21, my lord. Out of 21 witness, 4 witness has been examined, my lord, in this main time, my lord.
Whether you have enclosed the evidence of those who can.
No, my lord, there is nothing, my lord, against us, my lord.
No, I am asking whether you have enclosed their evidence.
No, my lord, no, I have not any.
You have gone for the record?
Yes, my lord, I have flag mark. Yes, the dying declaration is also there, my lord. PW2 is the, my lord, doctor, my lord, who recorded the dying declaration. Video clips is also there. They are the, my lord, parents on the day of the, my lord, on the day of the incident. In fact,
okay. Let him. Yes.
My lord, according to charge sheet, my lord, the IO, my lord, prepared two statements, my lord, 2 paragraphs, my lord. First, it's mentioned that there is a main culprit, my lord, accused person, my lord, Rubul Hussain and Firoza Bibi, my lord. Firoza Bibi is the sister of the Rubul Hussain, my lord. That another paragraph, they mention the 4 number accused person, my lord. They are the co-accused, my lord. It is clear according to charge sheet, my lord. Page number 29, my lord. It is clearly mentioned, my lord. The main culprit, main accused person, prime accused, my lord, Rubul Hussain, he is the husband of the victim, and his sister Firoza Bibi is the main accused, my lord. 2% of the main accused, my lord, culprit, my lord. And we are the showing as the co-accused, my lord. 4%, my lord. Out of 4%, my lord, 2% already discharged the name of the case, my lord. Again, there is no any evidence, my lord, witness, my lord. And now we are the parent of the, my lord, prime accused, my lord. We are the facing my lord travel, my lord, because we are the inside the judicial custody, my lord. But original, my lord, the main culprit, my lord, they are the outside in the jail, my lord. They are appearing the trial court, my lord, for facing trial, my lord. And we are ready also, my lord, we'll face the trial, my lord. And if the honorable court, my lord, grant bail, my lord, we are appearing regularly without any, my lord, fail, my lord. And my any terms and conditions, my lord, my prayer is that, my lord, kindly grant the bail, my lord, because we are the aged person, my lord.
That's right. What is the age?
My lord, age of the prisoner, my lord, now, my lord, 52 years, my lord. 52 years. And for 50 years, my lord. We are the husband and wife, my lord. We are the parent of the prime accused, my lord.
Now tell me, under section 130B also,
Yes, yes.
whether living in a separate house will make any difference here.
My lord, it is, my lord, based, my lord, according to FIR, my lord. In common case, my lord, if this case, my lord, happen, my lord, the family member will be, my lord, adduced, my lord, in any case, my lord, because we are the parent, my lord, we are the father and mother, my lord. That is why, my lord.
No.
And even, my lord, within the period of, my lord, within the period of 9 months, my lord, their FIR file, my lord, in the year of 2023, my lord, 3 June, my lord, 3rd June 2023, my lord. And charge sheet was filed, my lord, 26/3/2024. My lord. In the big period, my lord, the police person did not visit our house, my lord, and charge, my lord, us, my lord. That is only our name has been shown as the offender in the charge sheet, my lord. We are ready to face the trial, my lord. Already prime accused, my lord, granted bail or regular bail, my lord, they are outside, my lord. They are in outside, my lord. And they are also regularly appearing, my lord. We also want to appear regularly, my lord, in the trial, going to face the trial, my lord. There is, my lord, that if there are any, my lord, there is any, my lord, election, my lord, that, my lord, position of the case, my lord, will, my lord, prove, my lord. We are ready to face the trial, my lord. As on today, my lord, 8 months, 23 days, my lord. It is a big period, my lord. And now, my lord, only out of 21 witnesses, my lord, 4 witnesses has been examined, my lord. It is not complete within 2 years or 3 years, 4 years, my lord. Trial, my lord. It is not possible to, my lord.
Yes, Mr. Bhatt.
Yes, my lord. From the PM report, it reflects that victim died due to 90% burn injuries, my lord. And thereafter, my lord, dying declaration of the victim is also there, my lord. PW2 is the doctor, my lord, who recorded the dying declaration of the victim, my lord. The doctor's 161 statement and, my lord, deposition is also, my lord, I have flag mark. Actually, my lord, at that from the 161 statement, my lord, as per the doctor, my lord, on that day, my lord, at the time of death, my lord, on that day, actually, my lord, the husband of the petitioner was not present at the house. These are the main person who actually, my lord, these parents, along with one sister-in-law of the deceased, my lord, they, in fact, my lord, poured kerosene on the victim and thereafter, my lord, involved in murdering the, my lord, deceased, my lord. Main allegation is only evidence is against these 2 petitioners and one sister-in-law, my lord. There are materials against these accused persons. They are the main culprit. And I have trademark PM report, my lord, dying declaration, my lord, and statement of the doctor PW2, my lord. So there is no other evidence, my lord, required. Only dying declaration is sufficient, my lord, to, my lord, convict these accused persons.
No convicted, my lord. The trial is going on, my lord.
Yes, trial is going on.
Trial is going on, my lord. Just started, my lord. Only 4 witnesses has been examined, my lord, out of 21. There is it will take time, my lord, maximum time, my lord, for the prove the case, my lord, because position of the trial, my lord, is going on, my lord. As on today, my lord, can't say that he is a culprit, my lord. A doctor can't say that at the moment of the occurrence of the.
And, my lord, from the materials available on record, my lord, it is not a fit case, my lord. On the
That is why,
ground
my
of-
lord, we are the inside of the jail, my lord. That is why we are the passing of the 8 months on the 29 days, my lord. We are ready to face the trial, my lord. Position is there, my lord. Position will prove, my lord. And main culprit was the outside of the jail, my lord. And they are also appearing regularly, my lord, without any death fail, my lord. We are ready to face the trial, my lord.
Who were the main culprit that record?
Yes, my lord. And
We'll
position
open
is
the
there.
record.
Yes.
Okay, we'll pass the order.
Yes, my lord. I have trademark PM
Obliged,
report, my
obliged.
PW2 statement of the doctor, my lord.
Obliged, Mazul.
really, for being late due to my traffic jam. Last occasion, I was asked to submit the evidence of my TW in chief two affidavits, which I have filed. Perhaps Dr. was found the same impact. I'm under
You have
basic.
filed the affidavit.
Yes, I have filed that. Last occasion, my submission was such that on the particular day when the cause of action has been errored, in absence of proof thereof, whether it becomes purpose and also for the findings of position of the participant.
So there is concurrent finding of fact by both the court will.
So far, the concurrent findings as regards to my lord position, I have something to say so that the findings arrived at by the both the courts below as regards to my the position of the parties. Like, so far, that part is concerned, that is perverse, man. Because of the fact that lordship may take note the basic
Possession of the party.
yes, madam. Madam, they are claiming that their vendor were in possession, and after the sale was completed, possession was handed over to the respondents, and subsequently on a particular day, the present appellants have dispossessed them. That is why they have approached the honorable court seeking the relief of declaration of their right title interest and for eviction. That is their case, my lord, in nutshell. But our case is such, yes, their vendor has the owner of the land, and so far the disposition part is concerned, on that particular day, which the plaintiff, that is the respondents have claimed, on the particular day they were disposed, that is not true because we were in possession from long time. So for the possession and disposition part is concerned, but the courts below basically have not decided in terms and in connection with the pleadings of the parties as well the evidence and record, because so far the possession part is concerned, we were in possession, and so far the disposition part is concerned, that was not true. That is not actually elaborately discussed with region, but the courts will. I can point out all this fact. And so far that part is concerned, the decision of the learned courts below, put the courts below as regards to the possession of the respondents, this purpose. If you lordship take note of the paragraph 15 of the plain, which is at page 11 of my memo of appeal matter. This is the region which compelled the respondents to approach the Honorable Judiciary. Paragraph number 15, page 11, Your Honor.
No, you have already.
Yes, yes, fine. And so far the discussion as regards to that particular point by the learned trial court below as well as the appellate court below the side. Because so far, my cost of PW2 is concerned. PW2 was one of the purchaser to one of the plaintiff, which is the one of the respondent of this appeal. She herself stated that since 1971, we were in possession of the school. Now, so far the disposition part is concerned, and the position part is concerned, it is perverse, totally perverse to the extent of the available material available on that. That is why, my lord.
Then you have submitted 5 substance.
So far that part is concerned, my lord. substantial question number 2 and 5 are interconnected. I am pressing substantial question number 2. Lordship has pointed out as regards to whether in second appeal this particular question can be taken up. So for my petition under order 41 rule 27 is concerned, rejection of that. But so far non-consideration of that application amounts to my lord avoiding to discuss the position part, which creates the link with the substantial question number 5.
We'll go to the record.
Fine.
Pass the order.
Fine. One thing, my lord, so far, my lord, I have although annexed the petition under order 41 rule 27, but the documents which we have relied upon, which we have received for RTI, that is part has not on record.
Why?
My lord, that is my lord, submitted before the learned appellate court below, and if your lordship permits, my lord, we can my lord, provide the document if your lordship permits. Because
You tell me whether in absence of those documents,
even my lord, even your lordship, if your lordship take note of the statement of the my lord Mandals, my lord, 2 Mandals have been examined and cross-examined, and where from my lord, it appears that we were in possession, and the documents which we have produced before the learned appellate court below, that also reflects that the respondents were not in possession over the student. So far that part is concerned, but the courts below has not discussed. That's why this all is facts, my lord.
if necessary, we will again list them.
My lord, no problem. Highly obliged.
Having at 31.
May I please? Chief, on last occasion, Honorable Court told that the interim prayer will be considered today, Lordship.
May it please your lordship. Lordship, I'm appearing for the respondent for the first time today. We have not received the copy, therefore extra copy may be furnished to us. And regarding the prayer of interim lordship, this matter may come for admission and on the next date, as your lordship's convenience.
Next day.
Lordship, I have already I have served copy by way visual post and register, even though I will serve a copy, Lordship. But the petitioner is suffering from since last November, Lordship. The petitioner, father, and the son both are suffering from last November, Lordship. So kindly till next date, the interim may be considered. Only till next date.
Lordship, from what I have checked, Lordship, the next date fixed for family court Miss G 65 is 28th August of this month. So Lordship, before that day, any day may be fixed.
Before
that day, any day may be fixed for hearing on the
When the next day is fixed?
28th.
28
28th of August.
August, Lordship. So before that, Lordship may fix a date.
Or say it's not learned. Sir?
And our Sharma.
And it's not learned.
Lordship, on 28, sorry, Lordship. On 28, it is for settlement, Lordship. Already both the party, the learned principal judge asked both the party to proceed with settlement, Lordship. But till that, the respondent side has even stopped to allow us to contact with the child, Lordship. But that's why my interim prayer is much more necessary, at least till next date, Lordship.
Sorted.
Yes, Lordship. Lord.
He is not part a copy of the and of done by
Yes, Lordship. Yes,
11.
Lordship. I'm obliged, Lord.
For admission, Lordship. For admission. Hello.
Lordship, before my learned friend
I am
start
for petition.
for the respondent, before my learned friend starts, Lordship, I have, means the marriage is broken irretrievable. And almost a decade has passed that the parties have not met. And we see no signs because I've already verbally discussed with she has already consented for divorce otherwise. So it's under section 13A. So only thing is a permanent alimony if one date is there with both parties file a petition for a mutual divorce and a conditions of if they consent for permanent alimony.
Yes, that is then this admission is really it will be my lord.
So it's
We'll try to
changeable.
settle it.
Both the parties obtain consent. They could allow writing.
Right.
Right.
All right.
Lordship. Lordship. Is the query, Lordship? The
Your
number
Lordship,
one is
I am
present,
appearing
Lordship.
for one, the claimant.
Is a claimant.
My prayer is that since the delay is only 41 days, so your Lordship may be pleased to condone the delay. In the trial court also, the owner driver does not contest the case even after receiving the notice. My humble prayer is that the delay may be controlled and the case may proceed.
Lordship, the
So then we
order
have to
5.
track of the name of respondent
Yes.
for 20.
Yes, Lordship, order 5, rule 12 says the agent can receive in absence of the defendant. Lord.
Okay. Okay. Third is the PJ for number 1.
One.
The court submitted number 23 or the driver and owner.
Yes, owner and driver.
Vehicle. And they did not contest the claim application to the learned driver. And as their name record of the area of this application. Area according to the or the name of the court with the track of the area of the both applicant. The court order that there is delay of only this interlocutory application for day of or 1 day or appeal against the judgment and order. It is that for now application for 180 of 2009. It is here that by order dated the learned tribunal has awarded some with 9
9
for the court also submit that the delay of 41 days for the considered appeal explained in paragraph number
Lordship. Second one. I have duly explained, Lordship, from pair number 2 to 4, Lordship, 2 to Lordship 7, 2 to 7. 2 to 7.
and that and that the applicant has argued point or for getting cited and therefore allow this that learn for one of both the part admitted and keep the order path line from enter the appeal.
Highly obliged.
May I please before Lordship, I please before Lordship, it is this appeal was prepared as rejected by the impugned tribunal, my lord. Actually, this case is, this appeal is seeking permission withdrawing the FDR's amount, my lord. I have annexed, my lord.
For the first time,
My lord,
this is for admission today.
yes, my lord. Mr. Before Lordship, in this case, only 8 lakhs rupees was awarded by the RTT Cotton Bazar regarding death of my client, my lord, client's fund. My lord, 1 lakh was withdrawn as per order of that tribunal. And another 7 lakhs were fixed deposit as per order of that tribunal. And 2 lakhs for 2 minor sister of the deceased person, and 5 lakhs in of 5 lakhs, 2 lakhs for other, that means I appellant 1, and 3 lakhs where appear fixed for his mother. This is a lot. Actually, only ground is that we have thoroughly our life as nomadic life, because we are eroded person since 1990 River Brahmaputra. So therefore now we are laboring at Lucknow sitting here and laboring here. And we want to also as meet my lord. We just take a lot of land for permanent settling, and as there is no condition for proper education my minor children also against whom 2 lakhs will fixed deposit, but we want not for 2 lakhs minor, but only 5 lakhs minor. This is the case, my lord. As earlier filed before the tribunal, rejected on the ground that my lord. Any
Today we admit the appeal. Therefore, it is the part. Further,
the casualty across.
that Akla Kar- appeal direct the award against the judge that dated 30/5/5 passed by the third member that we claim RCT that we claim tribunal Guwahati Bank under section 33 of the Railway Claim Tribunal Act that in MA 30/55 of the I U 78 peruse the memo by the lender ground ground peruse the order dated 30/5 It is so beneficial by to the learned tribunal that the application by the appellant of getting the compensation amount that has been kept in fixed for the applicant.
In the bank of respondent number 2, my lord.
In the bank of respondent number that UCO Bank,
UCO Bank, okay.
Fortesa Bandra, Parvata Bank. That makes it not in the respondent. Rest of this is the matter. After 4 weeks.
Yeah, please, Lordship, I am appearing on behalf of my senior, my lord.
Sir. But we'll take up the IA, which is filed for condemnation of the delay. Lord, the delay has been explained in page 6 from paragraph 5 onwards, my lord. If I may take leave your lordship, my lord, to read the first title of judgment is a very short judgment.
Delay first.
No, I am.
Let us come to the explanation.
Yes, ma'am. Yes.
Paragraph number
5 onwards, yes.
5.
The applicant defendant fell into serious trouble because of an illegal judgment and order and was supposed to file a second appeal in this honorable court within 90 days from so and so date. But it was delayed for the following bona fide reasons. Applicant number 3 is the local head of applicant number 1, but he being the station superintendent remains swamped. Therefore, he was unable to take a regular stock of the situation regarding the case pending in the civil court. However, he came to know about the impugned judgment only in the last part of April 2018. The applicant number 3 immediately applied for a certified copy of the judgment, which was delivered to him on 26 April 2018. Thereafter, he wrote a letter to the then Law and Claims Officer Sri Nirmal Kakoti dated so and so. The applicant number 3 also informed Mr. Kakoti of the matter over the phone and requested him to place the matter before the applicant number 2 for necessary further action. However, for the reasons best known to him, he kept everything under lock and key till December 2018. In December 2018, Mr. Kakoti was discharged, and then the present Law and Claims Officer, Ms. Moyuri Kolita, took charge from him. It is relevant to mention herein that although Ms. Moyuri Kolita was appointed in September 17, Mr. Kakoti did not hand over anything to her despite several orders from the then Managing Director, ASTC. By this time, Ms. Kolita took over charge and department. She was already pregnant and due for her maternity leave from December 18 to May 2018. It should be May 2019, my lord. And she took childcare leave from June 18 to October 2019. Then, after she assumed her duties in November 19, she was a newcomer and thus took some time to bring the legal department into order, which was in a disorganized state and was in chaos. In the meantime, in March 2020, the COVID-19 pandemic hit the whole world and continued to February 2022, and everyone came to a standstill. However, the ASTC and its department were performing their duties in a staggered manner. Ms. Kolita, despite having an infant in her lap, continued working in the office and discovered a locked drawer inside. She managed to open the door forcefully and found the concerned file there. She immediately placed the file before applicant number 2 and started the required official procedure to take the necessary course of action against the impugned first appellate court's judgment. Ultimately, in September 2020, the file was handed over to the then standing counsel ASTC Sri J. Roy, who fell seriously sick inside the court, and he was indisposed since April 2021. The applicant did not retrieve the file, hoping that their counsel would recover and take the charge. However,
By April 2021, the applicant handed over their file to another lawyer, Sri N.N. Upadhyay, for the necessary action. But Mr. Upadhyay informed that the certified copy of the judgment, which was to be impugned in the appeal, is not available in the file. Then the applicants had to reapply for the certified copy in April 21, which they could obtain only on 15 July 2021. Thereafter, the Standing Council of the Appellants filed a civil revision petition on 16/8/2021, having a bona fide understanding that since the suit was for recovery of rent, it was related to the Assam Urban Areas Rent Control Act 1972. It is commonly understood that the second appeal does not lie against the first appeal in a suit under the Assam Rent Control Act. However, it was later understood after a long deliberation in the court that the suit was only for a recovery of money. As such, it was a money suit simpliciter. Therefore, against the first appeal, no civil revision shall lie, and it will be a regular second appeal. Now, a connected regular second appeal is associated with this application. Now, the calculation of delay, my lord. Total length of the days 22 March 2018 till 23rd July 2025 is 2678 days. Deduction under section deduction for the limitation 90 days. Then it comes to 2588. Relaxation by the Honorable Supreme Court for COVID period is 715 days. It comes to 1873 days. Now this point, my lord, that we spend some time in pursuing the CRP, civil revision petition. It is amounting to 1240 days. Well, we have shown it as deducted, and that is why it has come to 633 days. This is altogether in my respectful submission, my lord. The reasons that we have shown or we have narrated above, my lord, I believe in my respectful submission, this is sufficient, my lord, to show that despite there being a due diligence, my lord, this could not have been filed within the period of 90 days. My lord, I know that the state of if it is appealed by the government and it is appealed by a private party, the law is settled now that it has to be taken in the same category. The government or the government department cannot or shall not get any dividend out of it. Now, my lord, if I take your lordship to some judgments, my lord, which
not necessary. Here, you are entitled to deduction of 750 days on account of COVID period.
My lord.
Then after that deduction, there is 1,873 days.
My lord.
And you have spent 1,240 days in purchasing the letter in wrong product.
My lord.
There remain
633 days.
So that's how this calculation is different from your calculation.
Yes, my lord. This calculation is bad in view of section 14, my lord, of Limitation Act. My lord, first, if I arguing that section 14 Limitation Act, my lord, then the power given to the court will examine this period of wrong forum if the party approaches the court of a wrong forum and then he realizes due diligence, that whether out of due diligence he filed in a wrong forum, whether that was bona fide. So that aspect is to consider while considering an application for section 5 by the honorable court, that exercise of power under section 14 is not given to the registry or the office of the court. This is my first submission.
Pardon?
My lord, while counting delay under section 5, that office can calculate the delay as per limitation prescribed for filing appeal, that shall be minus.
That is only suggestion by the registry.
No, they have, my lord, calculated 633 days.
Not with them.
Yes, then, my lord, how they can, my lord, minus this period of approaching a wrong forum? There is some judgment.
You tell me
Yes.
whether the applicant herein is entitled to get the same period deducted from the total period.
My lord, while submitting that, my lord, my submission is that, my lord, the total period while calculating by registry, that has to include this period, the wrong forum period. And this period, benefit of this period, he will get, because in the event honorable court found, yes, he approaches in a wrong forum out of due diligence and bona fide. So therefore, this wrong forum period will be considered by the honorable court.
Going by the explanation so forthcoming,
Yes.
can it be said that it is not bona fide one?
No, so far, my lord, for the purpose of this 100 to 1240 days, lordship will held. Yes, it is bona fide. He was approaching in a wrong forum.
I am asking you,
Yes.
in the background of the explanation so forthcoming for
Continuation of delay, whether there is
can it
sufficient
be
causes.
said that it is a not bona fide one?
My lord, so far 633 days are concerned. There in the initial period, I have the objection. I will place that, my lord. Now, so far the manner granting deduction by the registry. No. While calculating the delay,
That the friend is finding fault with the registry. All right, if registry has committed something wrong, lordship is there to make it correct. Lordship then
to tell the period will
this is a
differ.
technical thing. This is a technical.
No,
Let us argue on the merits.
Yes.
These are technical things. Oh, fine. My friend is
My
correct in saying that this 1240
submit
this 1240 days, according to my friend, ought not to have been deducted by the registry, because under section 14 of the Limitation Act, registry shall not do this. But while calculating or while passing an order on this petition, this power is with your lordship to say that this 1240 days can be deducted or not, whether the time spent was bona fide or not.
Okay. That's why
My lord,
That is a technical aspect.
if he
of
has
it.
complete, my lord, now let me place.
Mr. Das,
Yes.
tell me, is there anything to suggest that this period is not a bona fide one?
My lord, that is maybe bona fide if lordship hails it. In considering a IA application where,
Therefore, I am asking,
yes,
is there anything to suggest that this delay of
Yes.
1240 days are not bona fide?
Mala, as per section 14, he is entitled. But that entitlement from a declaration by the honorable court, because lordship kindly see. No, my lord, there is some judgment because section 14.
No, Mr. Das.
Yes.
That's why I am asking. Is it not a bona fide one?
My lord, if it is bona fide, yes, it is bona fide. For argument's sake, it is bona fide. He was approaching in the wrong forum. That period he should get under section 14. Now, who will give him this period? The honorable court will give.
No, that's why I am asking you.
So, in the total calculation, that 1240 days will come. For wrong calculation, moreover, my lord, lordship, he has withdrawn the case on 25/7. I have enclosed that order, my lord, in page 24. He withdrawn the case on 25/7. And he filed the case prior 2 days thereto. He filed on 23/7, my lord. Yes, page 9 of your bill. He filed it on 23/7. How the registry will know that actually he will given benefit by the court under section 14?
Sir, does you forget about the registry?
My lord.
Forget about the registry.
Yes. Now, so far the original period is concerned, my lord. 630 days.
Yes.
My lord, to that effect, I have filed that affidavit. My lord, may kindly have a look my explanation. Para 7, my lord. Para 7. The statement may interpret are not tenable as such the same are not admitted by the court. It is stated the impugned judgment was delivered on 22/3/2018 and the copy of the judgment was obtained on 26/4/2018. He received the original judgment, my lord, on 26/4/2018. It appears a decision for filing appeal was taken by the applicant only in the month of September 2020. They approached first time the first council in September 2020, my lord. And accordingly, file was handed over to the standing council on the applicant in the month of September 2020 only. It is apparent the applicants took 1 year, 5 months time for taking decision for filing the appeal against the impugned judgment and for engaging advocate. For the period from September 2020 to April 2021, for a period of 7 months, there is no correspondence from the date of engaging the earlier advocate, what he has done, what is the communication in between, is it the responsible department, my lord, they will sit until and unless the infinity that the advocate will waiting for filing, my lord. So there should be some communication as to what you have done, we have given you the file. So from the day of September 2020, when they engage the advocate, till they return back the file in April 2021, my lord, for 7 months, there is no communication from them. So that reflects, my lord, their lessons, the negligent and careless attitude, how to take steps against the impugned judgment. This is my submission first. My lord, next line, the statement made that the standing council was sick for the period September 2020 to April 2021 is also not supported by any medical document. They have just made a bail statement that the earlier council was ill. The applicant states the explanation put forward by one.
Mr. J. Roy, Jyotirmoy Roy, now this is a council, he fell down in the court itself by a heart attack. And he was in hospital for
At least one document, my lord.
Well, I cannot, because it looks odd if I feel sick tomorrow and my friend is asking for a medical certificate from my wife. This is difficult because we are asking for a condonation of delay. I know this is my right is limited. I'll show the authority of the Supreme Court, which says when it is to be considered in a liberal way.
No, that is well said.
Well
Yes,
settled.
yes. Justify
This is
sufficient
not
cause.
sound. This is not, at least from BK Das, it is not sound.
Please.
At least from BK.
Next explanation, my lord. Next explanation, page 16 only, next para. The applicant states the explanation put forward that one Mayuri Kalita was appointed as a law and claims officer in the month of September 2017 and she took shares of the office in the month of September 2018 from the then law and claim officer so-and-so in the month of December 2018, and while taking over the shares of the office of the law claims, it is not understood as to how the applicants could allege that she was not handed over the particular file. If a new person come, it is a government office, my lord. Then if a new person come, it is understood that she has been given all the shares. She has given shares, but the particular file is not given. How far it is correct, my lord? These are lesses, my lord. These are negligently, they have made the statement, irresponsible statement, my lord. Then after, my lord, the statement is also not supported by correspondence later issued by MD ASTC, except a bail statement that the file was not handed over. Where is the document that, or had she made any application or the representation showing the higher authority that yes, this particular file is not given to me? And whether she any communication correspondence office note that although I have joined your honor, that no, I was not given the shares. There must be something. And next paragraph, that as per explanation made in paragraph 5.2, 5.4 of the IA application same absolutely not tenable. The office of the applicant being a public office, there is a procedure for handing over of shares while going on leave. Since Mayuri Kalita went on maternity leave from December 2018 to November 2019 for a period of 1 year. Therefore, it is absolutely beyond one's imagination to wait for her for taking decision for filing appeal against the impugned judgment. The statement made in para 2 of the IA application that MS Kalita went on maternity leave is also not supported by any document, medical document. As such, the same is denied by the deponent. As far as the statement made in para 5.3 and 5.4, the IA application, the deponent states that period from 15/3/2020 to to 16/8/2021. Malad 16/8/2021 is the date when they filed the CRP. So COVID was declared from 15/3. So 15/3 to 16/8, this benefit they have been given was excluded by the Honorable Supreme Court by order dated 10/1/2020 sumo to repetition number so and so due to widespread COVID-19. But in the present case, the delay from the date of receipt of impugned judgment 26/4/2018 to 15/3/2020 is 689 days. And even during this period, applicants failed to take a decision for filing the appeal. Malad, they want to take the benefit of COVID period, and within the COVID period, they have filed a CRP. However, as per the order of the Supreme Court, they will get that period, and they has been given rightly. But their conduct of proceeding or taking recourse to take action against the particular decision, this is bad, Malad. This is lapse. This is negligence. Malad, if this lapse and negligence are there, Malad, and if it is not sufficiently explained with some contents.
Maybe in one of the decisions has stated
Malad.
A government officer there is usually the part
Oh, but while Malad, in such a long delay, there is also judgment saying that the court should sympathetically look into the delay in a short term of delay. But if it is delay is long, years together, then Malad,
that is the
parameter. Malad, I will place Malad. This is our duty to place Malad. Now, kindly see Malad, page 18. Next.
Order long, that is not the criteria. How
Sufficiency.
Yes.
Whether is the sufficiency.
That's correct, Malad. Whether there is a sufficiency, Lordship will decide that, Malad. Whether they have explained sufficiently. Now, page 18, Malad, that the statements made in para 5 of the IA application are having no substance. Although in the month of April 2021, the applicant engaged another advocate and handed over the file but did not contain the impugned judgment. So it shows that careless and negligent attitude on the part of the applicants for taking recourse against the impugned judgment. They have given the file without the impugned judgment, my lord. Is it the statement, my lord? Can it be believed, my lord, that the statement made in para 5 shows that delay occurred due to lapses and lapse on the part of the applicants. Even it appears the applicant failed to take decision taking recourse or filing appeal against the impugned judgment within the prescribed period of 90 days, since the decision for filing appeal has been taken only in the month of September 2020 when they initially engaged Mr. Roy, my lord. That is after 1 year, 5 months. The date of receipt of the certified copy of impugned judgment makes it abundantly clear that applicants were never serious and vigilant for taking recourse of impugned judgment, and as such, explanation put forward is not sufficient for continuing such long delay. On the next parameter is important. It is I have dealt with section 14. With regard to the statement made in para 5, 6, IA application depends states that the IA number so and so, withdrawal of CRP number so and so, along with interlocutory application connected therewith, which was filed on 16/8/2021 by order dated 25/7/2025. The Honorable Court allowed the applicants to withdraw the CRP with liberty approach the court appropriate application. However, the Honorable Court did not comment for exclusion of the period 16/8/2021 to 25/7/2025. Therefore, the period of 1240 days has to be calculated.
Court will take into account this.
Mala, either the court where they have withdrawn, court might have said, my lord, that in view of the long form, he will get the Article 14 benefits. That was not there. Malad, if that is there, then while, in my humble submission, while calculating the delay.
No. You tell me, is it a requirement of law that the earlier court observed that if landed
Normally, that was,
No, normally usually forgettable.
yes.
Whether it is provided in the act.
No, nothing, no.
Act doesn't
not
say
there,
anything.
Not there.
Then
No, I have made this statement because of the fact, my lord, while filing this, appeal, my lord, the delay for the wrong period has already been condoned. I am on that, my lord. That condonation benefit of the wrong forum can be given by the honorable court. In total days of calculation, 633 plus 1240 days, this is the, my lord, total days. And 1240 days will given by the lordship.
Then
While-
again, it comes to six.
Yes. No. Total delay will be
Yes.
initial. I have given the table also, my lord.
Yes, from your table, I am saying.
Initial delay,
From your table, I am saying.
page 20,
Yes, come.
6.
According to you,
No,
according to him.
Either you say or I say.
No, I'm just explaining.
Oh.
According to you, total delay should be 1873 days.
Yes.
Registry or I myself deducted 1240 days. So if 1240 days is deducted, then remaining is 633 days.
Cannot.
Now, see, minus Krishwa.
Oh, this minus, my lord, in my humble submission, what I understood after going through some judgment, that exclusion of period under section 14 requires determination and the court will grant. Court may grant.
Now,
But
my lord,
in
what my friend is suggesting is that your lordship should say in order that the total delay is not 633 days, total delay is 1873 days.
Why it
That's
will
what
be-
my friend is saying.
That will not be said. This calculation, how the calculation will be made, kindly see, my lord.
That's what I am saying.
Calculation-
Lordship will make an observation according to my friend that the total delay should be 1873 days as per his calculation.
Let me my lord, read the next paragraph, please, my lord. He will. Page 19, my lord. And it will be, my lord, the middle from. However, the honorable court did not comment for my lord, so I have read out, my lord. Therefore, the period of 1240 days has to be calculated by the applicant along with the original delay of 633 days till withdrawal of the CRP on 25/7/2025. And in view thereof, the total delay is 1873 days and not 633 days. And on this wrong calculation of delay, the delay condition application liable to be dismissed. Now, with regard to the calculation of delay, there are 6 I application difference. This is delay in filing the appeal is 1873 days. Now, wrongly calculate the delay of 633 days. Yes. My lord, while the period of limitation is 90 days, they will get the benefit. Rightly minus that 90 days by the office. Rightly. Now, relaxation by the, as per the decision of Honorable Supreme Court, they have got 715 days. This is correct. So, these two, my lord, deduction could be only look into by the, my lord, while calculating the delay. So far, Article 14 is, Section 14 of limitation is concerned. This is for the purpose of the Honorable Court while considering, because this period lapsed in a wrong forum. It will get, he cannot himself calculate by getting the deduction in a wrong forum. This is the decision, my lord. This is my submission.
No, one is not claiming it.
And therefore, he has 633, he has calculated.
No, he is suggesting it.
No, my lord. In the I application, kindly see, there's a total delay is 633 days.
Yes.
It could not have been. Total delay is, my lord, 1873 days. And lordship will grant for 1240 days and 633 days subject to his explanation. This is my understanding and my submission. Next para kindly see. It is stated that the time spent for the period 16/8/2021, that is from the date of operation of wrong forum, by way of filing revision petition against the judgment and decree dated so and so till withdrawal of the same on 25/7/2025, is to be demonstrated in the condonation petition. This is his one of the ground in a wrong forum, my lord. As sufficient cause which subject to consideration by the Honorable Court under Article 14 of the Limitation Act. Such delay cannot be excluded by the rest under Article 14 of the Limitation Act in a routine manner. Since the raising of the court deals with the administrative procedural matters, while as a process application for condonation delay, they do not have the authority to make judicial decision about applicability of provision 14 of Limitation Act, which requires determination if the previous proceeding was prosecuted in a good faith and with due diligence. That this part is for your lordship. Due to due diligence and in good faith, the petitioner was prosecuting in a wrong forum, and therefore he is entitled for benefit under section 14 of Limitation Act, and therefore he has sufficiently explained this period, 1240 days period, while considering section 5 limitation, my lord. But neither the petitioner himself can already take the benefit of this. No, he cannot. This is one of the ground in the section 5 application. This is my respectful submission, my lord. Therefore, counting of delay by excluding the period spent in wrong forum by without any basis, that too when there is no order from the Honorable Court for exclusion of such period. Add to, my lord, otherwise lordship may resume. Add to, lordship may resume.
Is there any here again?
Yes, my lord, some judgments. Sir.
I have also given a compilation, 2-3 judgments.
Let me write the paragraphs. Which para?
You can mark it.
Yes, sir. Malad, in fact, on Article 14 also, that judgment is there, Malad, how to deal with. This is for the court to determine. Because section 14 is just one line, Malad, one submission. Limited. Just one line, Malad. Malad, 14 limitation activity. 14 to kindly see, Malad. তুমি এইকেইটা ইয়াতে লিখাচোন সেকশনতে এইকেইটা 14 2 মাইল জাস্ট মিলাই হয় নেকি in computing the period of limitation for any application, the time during which the applicant has been prosecuting with due diligence another civil proceeding, whether in a court of first instance or of appeal or revision against the same party for the same relief, shall be excluded. Where such period is prosecuted in good faith in a court which for defect of jurisdiction or otherwise of like nature is unable to entertain it. My lord, there lies the, my lord, determination and lordship's declaration. Yes, in good faith he was prosecuting the wrong forum, and therefore under section 14 1240 days he will get the benefit out of total, my lord, delay. This is not for the applicant to calculate and already, my lord, minus this period. This is my submission. Yes, because this is wrongly, my lord, calculated by the petition. That's what. And the judgment is on the same point, my lord.
Okay.
My lord. Obligation.
The
6th of August. 6th of August.
My lord, one submission, my lord. Since this is a regular second appeal, my lord, so far the IA application for stay is concerned, I have objection to that, my lord. Because of the fact 2025 2 SCC page 215, my lord, the Honorable Supreme Court said, my lord, that without there being a substantial question of law framed, and that too when there is delay, first the substantial question of law has to be framed, and then question of stay will come, my lord. So therefore, my lord may here, yes, without there being a,
application.
yes,
Unless and until we of the second appeal does not arise.
yes,
If we confirm the delay, then the SC will
right,
consider
yes,
second
right,
appeal.
right, yes. Right.
Then unless and until we admit and admit the second appeal, the question of stay does not arise.
My lord, deeply over.
Deep. Obliged.
May I please your lordship? Lordship, in this matter, we are led by Mr. Senior Counsel Mr. D. Mojumdar, and he is not available today. Matter may be taken on this Wednesday or Friday.
It's your good name.
MSK Bharali.
Lord, the appearing on behalf of sir.
Peacock. Peacock.
Lord, applicant price for Wednesday. Here,
Much okay.
this like
Much obliged, Lordship.